I went from failing paper 3 dismally on my first attempt to getting a distinction on my second try. In this video, I want to share with you tips and tricks as to how to go about passing paper 3. And no, it really isn't that difficult. Hey, what's good, beautiful people? Welcome to my channel. My name is Shella, or you can call me your lawyer bestie. And I am an admitted attorney of the High Court of South Africa. And like you, once upon a time, I had to write paper 3, commonly known as ethics. But I want to start first by saying that this is not an ethics paper. Let's start there. This is not an ethics paper. That's what made me fail. When I was preparing to write this paper for the first time, I really took it as an ethics paper, and so much of my focus, actually all of my focus, was on the ethics part of things and not everything else. And I was in for a huge surprise. I remember when we had finished writing the exam at Empress Palace, and I went to, the golden bathrooms. If you know, you know. So when I got there, I remember just ranting to a girl I found in there. I was like, how can a whole ethics paper not have ethics in there? And she just looked at me like, yeah, no, that paper was just, it wasn't easy. It's only when I was preparing for the second time, I was like, that question I asked that girl was actually very dumb, because that paper is attorney's practice. It's not just ethics. So that's already something that you need to take into account, that you need to study everything pertaining to the practice of an attorney, not just ethics. Ethics is a part of this paper. It's not the paper. It's just that the paper is nicknamed ethics, but that's not what the paper is about. So don't fall into that trap. So in my preparation phase between the two times, I can tell you that realizing that this is not just an ethics paper, but attorney's practice. So that means everything an attorney must know, my strategy changed. And the thing with this paper is that you are acquiring knowledge that you are actually going to use in practice. There are certain parts of board exams that you study and you write the exam and you pass, but you're most probably never going to deal with that aspect of law. But this, with paper 3, you are definitely going to come across these things in practice. There's no way you will not come across any of these things that you learn in this paper. So just take the studying of this paper more seriously, and just like more personally, in that this will really be something that you will need in practice. It's not all of us who do deceased estates in practice, but obviously you had to write paper 2 in order to get to where you are. It's not all attorneys that deal with, trust accounts and, all of that stuff relating to bookkeeping. It's not all of us who do that. But things like being an ethical attorney and the things relating to the practice of an attorney, you're going to need, whether you are a practicing attorney or a non-practicing attorney. So when it comes to studying for this paper, don't study for this paper in isolation. In the exam, you will get questions that might be similar to something that you might get in court procedure or even bookkeeping, because this is relating to the practice of an attorney, not just one singular subject. So for example, you might even get calculation of damages, and you might be thinking, paper 1, is that you? No, it's not. You might get this in paper 3, or things like drafting. You will find a whole lot of drafting in here, and you might even find like a young aspect of criminal law. Like, it's really everything pertaining to the practice of an attorney. So don't study the subject in isolation. So my personal opinion, this is just my own personal recommendation, and that is, don't start with ethics on your first attempt. So for example, if you are writing, let's say, 2 papers in one sitting, and then you're going to write the other 2 papers in the next sitting, I don't recommend that you start with ethics. The reason for this is that there are a lot of things that you study in the other papers, like maybe for example in paper 1 and paper 4, that you will use in ethics. So I think when you start with ethics and you haven't done paper 1, you might get a little bit confused about things like calculation of damages, certain things that must be in pleadings, because that topic is explained quite heavily in your paper 1 notes. So when you have started with paper 1 already, it's like you have indirectly started studying for ethics, if that makes sense. So I think Don't let paper 3 be that paper that you jump into as like the first paper that you write. I don't think that is wise. This, of course, does not apply to people who are writing all 4 papers at the same time. If you are writing all 4 papers at the same time, by all means, write ethics as well, because you're already studying for paper 1. You're already studying for paper 4. So that knowledge, you already have it. So I think you'll be able to pass your ethics exam. And also, if you haven't attended law school, ethics can be a bit tricky. It really can. So if you want to attempt ethics before attending law school, you most definitely can, especially if you've got extensive notes and you've got somebody helping you. I think you can do it. But if you don't have external help, you don't really have the notes, like you just want to go in there and see what can happen, I really don't recommend you doing that. That's just my own personal opinion. Another tip I want to share is this. Please learn the theory behind the drafting. Don't just learn or cram the particular pleading or the particular notice or, whatever it is. Don't just cram that. Know the theory behind it, because when you know the theory behind it, you'll be able to draft better. I explained this in the paper 1 video where I said that, for example, if you don't know Rule 18 of the High Court rules, that is rules relating to pleadings generally. It says things like, if you're relying on a contract and particulars of claim, you need to attach it. Pleadings must be in paragraphs, things like that. So when you know that theory, even when you draft, you won't write one big paragraph and say it's a pleading, because according to the rules, a pleading has to be divided into paragraphs. So when you know the theory or the rules behind a pleading, you draft better. When you know what points need to be in let's say a partnership agreement, it'll be easier for you to draft a partnership agreement, because you know that according to the theory or according to the rule, these are the things that must be included, and that's what you will include in your drafting, and you will come out stellar. Because sometimes, even with things like partnership agreements, you might find that the question is asked as a theory question. And when it comes to ethics, the questions can be a bit tricky, because it's like 2 marks, 1 mark, 3 marks. Like you get questions like that. You might find a 60-mark question. Let's say question 3 is out of 60 marks, but it's divided into 10 here, 5, 3, 1, 2, 11, like that, until it makes up 60. So if you don't know the theory behind the drafting, you will lose a whole lot of marks in the exam. So just make sure that you learn the theory and then the drafting. And then the next thing is study for yourself. Make notes for yourself. I highly recommend this on all 4 papers, making notes for yourself, because relying on somebody else's notes denies you that opportunity of you using all your mental and physical faculties to grasp concepts. Because when you make your own notes, it's not just you writing stuff down or writing what you remember. It's your brain working. It's your physical body working towards this. Like your whole body is engaged in you learning this thing and grasping this concept, as opposed to you just reading somebody else's notes. And with people's notes also, you find that they have summarized in a way that they understand. And you read that person's notes, and there are certain things that don't make sense. In most cases, you will just skip those parts that sort of don't make sense, and that's going to be to your detriment. And like I said, this is a subject that you're going to use in practice. So just put your best foot forward by being diligent. Another thing, because this paper has a lot of drafting, I want to say that use the Legal Practice Council scope to see how much of the drafting you know. So the legal practice scope says, like you see here, deeds of sales, partnership agreements, sureties, acknowledgement of debts, power of attorney, option, right to preemption, like all these things. Look at the scope and then just tick off what you know. Tick off what you know. Once you have done acknowledgement of debt, tick it off, because that measures how much you need to know. Because that's the scope. This is what you need to know. So when you look at the scope and you just tick off what it is that you know, it's going to be so much easier for you. So how I divided the paper while I was studying, I divided it into ethics, right? So I had the ethics portion of things, and then I had, you see on the part of the scope where it shows the drafting, then I had the theory and the drafting. So when I was studying, I had 2 big chunks. So one chunk was ethics, and then the other chunk was this, which relates to the business side of things, the drafting. I had that one on another chunk. So with my second chunk, I made sure that I knew the theory as well as the drafting, and then I knew the ethics behind certain things. And I remember that paper so well. And I remember when I wrote this paper, ethics was not like a big part of the paper. I think in the paper that I wrote, the one I got a distinction in, if you just studied ethics, you were not gonna pass. And that's what happened to me with my first attempt. I focused so much on ethics, and ethics didn't really come out in that paper. So I think when you're studying for ethics, just keep that in the back of your mind, that this is attorney's practice. Anything can happen. It doesn't just have to be ethics. Okay, now let's jump into things that I think are important to know when it comes to ethics. I'm not really going to focus on the drafting because, that's drafting, and I think you need to know the theory behind the drafting for you to come out stellar, and that's just a lot. This is not a tutorial, it's just tips. So let's see. Okay, things like the duties of an attorney. Of course, you need to know this. So it is the duty to be absolutely honest, the duty to obey your client's instruction. Please obey your client's instruction. You are meant to give your client advice, show them the possible ways, explain it to them fully, and then the client makes the final decision. The client instructs you. You don't instruct the client. So the client will let you know what route they want to take, and you need to obey that. But you need to make sure that if the client is choosing a way that you think will be detrimental to them, you need to advise them and show them the possible outcomes as well as your opinion. But the final instruction comes from client, not you. And then there's also a duty not to corrupt the administration of justice. A duty of confidentiality. That's also like a big thing for you to study in this topic. Confidentiality. A duty not to abuse the court process. Attorneys be doing the most with this one. I'm not naming and shaming. I'm not going to name and shame. But, people be taking matters for litigation when negotiation could have been the easier route. Don't do that in practice. And then there's also a duty of honesty and reliability towards the profession as well. So just know the duties of an attorney. These are things that, even if they don't ask them in the paper, it's good to know what your duties are as an attorney. And then fit and proper. You are about to be admitted into the legal profession. You need to be a fit and proper person. What is fit and proper? What does fit and proper mean? And that is showing characteristics of honesty, reliability, and integrity. And then prescription. What do you do when a client comes to you with a matter that has prescribed? Do you just chase them away, or can you take that mandate? So when it comes to prescription matters, you have to explain to the client that the matter has prescribed, and explain what prescription is in basic terms so the client actually knows what's going on. And then once the client has been informed, the client will then make a decision, and then they will say, you know what, I still want to continue with this matter, and then you continue with the mandate. It's only the defendant that can raise prescription as a defense. So the magistrate cannot say, but this matter has prescribed. Why are we proceeding? The magistrate is not entitled to do that. It's only the defendant that can do that by way of a special plea. So they don't just stand up in court and say, hey, this matter has prescribed. No, they don't do that. They have to raise it via a special plea. But if the defendant does not raise it, the court will not be able to raise it. And then the matter will be adjudicated as if the matter had not prescribed. So that's important to note when it comes to prescription. I feel like this video is slowly turning into a tutorial. Fees. Know the sharing of fees. When can an attorney share fees? Can an attorney share fees? And with who? Can an attorney share fees with an estate agent? No. Can they share fees with an advocate? No. Can they share fees with a candidate attorney? No. Who can they share fees with? Another attorney. That's who you can share fees with. So make friends in this profession, hey? So that you refer matters to your friends and then you can share fees. It's a win-win. And I remember this question from one of the 2 papers I wrote, and they were like, if you are perplexed and you get into a situation where you don't know what is ethical and what is unethical, what are you supposed to do in that instance? So the first thing will be you consulting with the relevant authorities, that is books or journal articles. Look at case law and see if something like this has happened in the past, and if so, what's the proper way of going about it? Or consult a senior colleague who will be able to shed some light, because obviously they've got more experience and maybe they have come across something like this. And if you still haven't found answers in the first 2, the best thing for you to do would be to contact the Legal Practice Council and just be like, yo, I'm seeing flames, help. Can you borrow from a client if you don't have money and you know that your client is loaded? Because you have information to all these things and you know that your client is balling, he's a baller. Can you borrow money from a client as an attorney? And the answer is no. You cannot borrow money from a client unless if the client has received advice or financial advice from, a third party other than yourself. That's when the client can borrow you money. But also just knowing our statutory body and what their role is, like knowing what the Legal Practice Council does or the Law Society, know those things. Even if they don't ask it in the paper, just know what the Legal Practice Council does. And then mandates, when can you accept a mandate, when can you decline it? So you can decline a mandate if you do not have enough experience or knowledge in that particular area of law. So if a client comes to you and they've got a property law matter, you are able to decline that mandate because you don't really know much about property law, and then just refer the client to somebody else. You can do that. Or if you don't have the time, sometimes you're just so swamped and you cannot take on another matter, it's best for you to decline it. Also, in instances where there is conflict of interest, it is best that you do not take that mandate. Admission and readmission. Know what the requirements are that a person must satisfy in order for them to be admitted, and then know what the requirements are for a person who has been struck off the roll to be readmitted. There are 7 factors that must be taken into account for you to be readmitted. If the court is satisfied that a person has satisfied the 7 requirements, a person can be readmitted as a legal practitioner. So you want to know that. Also, things like cost. Know what cost bonus proprio means. Know things like acting pro bono or acting pro amico. You have to know these things. So I think I'm just like reiterating the stuff that's already in your notes that you must study. But I want to also say that know the theory behind the drafting. When it comes to like the business or like commercial side of this paper, make sure that you know the theory and you know the drafting. So like I showed you on the scope, look at the scope and then go over the theory and then know the drafting. There's literally no other tip that I can give beyond that, because that's what helped me to excel, by literally doing that, focusing on ethics and then on this part, not just on ethics, because ethics alone is not enough for you to pass. Ethics alone actually I think is a fail, because I've never seen a paper where ethics is asked for more than 50 marks. So yeah, that is it. Those are my tips that I think you need to take into account when you're studying for this paper. And yeah, relax, take it easy, go at your own pace. I know during this time everybody will be like, did you study this? Do you know this? Do you know that? Did you cover this? Did you cover that? And it can get so overwhelming, especially if you haven't covered those topics. So I think it is best that you go at your own pace and you minimize distractions. So put yourself in a position where you're not comparing yourself to other people. So I wish you the best of luck in your paper. May you prepare adequately. The reason why people fail board exams is that they have not prepared adequately. So prepare adequately and do the best that you possibly can. And with these tips as well, I don't see why you will not pass paper 3. Until then, I'm sending you tons of love and light. Bye.